Well, good morning. Welcome to Monday morning power sessions. So, Kim and I wanted to review some things that a lot of agents should be aware of when it comes to homeowner associations, condo associations, and deed restrictions. And one of the things that we end up seeing a lot of times is when you are representing a buyer, or even when you go to represent a seller on a listing, what is what is an HOA? What's a condo association? And how do I navigate what these restrictions really mean? And I've always wondered in real estate, the very first thing that you should be thinking about when you're a buyer's agent is, does the property fit the buyer's intended use? Now, so many times I think we're so eager to get out there and put an offer into a home. And then all of a sudden we start thinking, oh, what does the client want to do with this property eventually? What's the future planning on this property? And I think that's a step that I think that we always glaze over. And I would encourage all of you, as moving forward, when you are a buyer's agent, take a pause, ask your client when you're going down buyer agency, what's their intended use of the property? And for example, can the buyer install a pool? Maybe that a pool is an important feature. Can they build a fence? Maybe they have small animals or dogs that they want to keep in. Maybe a pole barn or an outbuilding. So many people are wanting those. Uh, will the property allow it? Something that we're going to explore. Here's another one that comes up. I like this home as an investment, and I want to use it for short-term rentals. Is that allowed? What about chickens? I want to park my RV or my boat. I want to have a trailer. I want to have a commercial vehicle. Is that allowed? Is that are those allowed? Is that what your buyer's intended use is going to be? And then what about exterior changes? We don't think about that often, where someone comes in and they want to redo their property and maybe they want to change the exterior. Well, the homeowners association may require that it look and have a certain feel, or even I've even seen certain colors are required, which is crazy, but it's out there. So I caution all of you that when you're a buyer's agent, ask them what's their intended use of the property. Does it fit the buyer's intended use? The buyer should address a lot of these issues during their due diligence period, and if appropriate, even terminate the agreement before their deadlines expire. Now, a lot of agents will always ask, well, how do I determine whether there's an HOA or property restriction, right? That's the big one. You're doing research. How do I know? Well, you you can't rely on one source alone. That's the problem. We always think, well, the listing agent should tell me. And then we fall in that trap of, well, the listing agent never told me. Well, of course, because probably the listing agent didn't even know. So uh, there there are some keys that we can look for, some ideas when you're searching for as a buyer's agent. Start with the MLS. That's the very first way to look when you're looking. Look for from the listing agent, are there any HOA dues that are being listed there? What about condo dues? Is there an association name, subdivision name? When you're doing research, is it in a subdivision? That might be an indicator that there's an HOA or a site condominium that's being referenced. And, here's another one that gets lost is a private road reference. Is this home on a private road? And we'll get into that in a little bit. Or when a home is on a lake, is there a lake association reference? So there's a lot of things that agents we look over all the time, and a lot of us, I think we just get lucky that there isn't something in that HOA or condo or lake association or private road reference that we have accepted when in fact we probably should have looked at that a little more deeper to ensure that it met the buyer's intended use. When you are looking to determine whether there's an HOA or condo, the MLS, like I said, is the first place to start. You might normally see association dues, 450 annually. Anything that's saying an annual due should trigger you to think, okay, there's more to this that I need to explore. There's a lot of things I need to find out. The MLS might even have private road or lake access. Any of these terms should be indicators to your mind to think, okay, there's something else here. The listing agent just hasn't told me. Where's the private road agreement? Where's the lake association reference? If someone is telling me lake access, because I can guarantee you there's certain stipulations about being able to access that lake or an easement. Another situation that people can look in is the seller's disclosure statement. So not only do we have the MLS, but seller's disclosures can help us determine HOA or condo. Review that seller's disclosure. Look for any references to associations, restrictions or dues or assessments. Like I said, shared roads. Here's an area that gets overlooked: common areas. Sometimes in condo associations, you have common areas like a pool. You're going to want to know, are there additional expenses for the common areas? Well, yeah, it's called your annual fees or your quarterly fees or monthly fees, but you need to look. Maybe that condo association has a clubhouse that you can use. Maybe it's free, maybe it's not, maybe you got to pay for it. We have to find the information that sometimes the listing agent will not provide to us. Another place that people can go, County Register of Deeds. You can always go there and you can find recorded documents that will typically give you the best evidence of restrictions that affect a property. So, for example, you can search for deed restrictions. You can search for subdivision covenants. A lot of times they use these fancy word called declarations, uh, or they're really just master deeds or bylaws. Uh, Condo bylaws, there's private road agreements. A lot of these will be found in the county register of deeds. So that's the third location. I often give the example that a buyer wants to build a pole barn, and the recorded subdivision restrictions they prohibit detached outbuildings. So now we really want to ensure that the buyer evaluates this before waiving their contingencies or proceeding to closing. There's nothing worse, and I'm telling you, there is nothing worse than getting past your due diligence period. And then you have to tell your buyer, hey, guess what? I know we talked about that pole barn that you really want to have. It's a must have. Well, we just kind of found out that you can't have it. It's the worst feeling. So try to avoid that. Believe me, it's not fun to be in that position. So where else can people find information on a property? Your title commitment can help you. And inside your title commitment, there's what's known as a Schedule B. There's Schedule A and Schedule B. But Schedule B typically will show you the restrictions within the property. They appear as what's known as title exceptions. And these might be obviously placed in the MLS by the listing agent, but Schedule B, no matter what property you're buying, agents should always review the title. Don't automatically assume that the title company is going to tell you and do everything for you. Hey, title companies are great at things, but they sometimes can miss things. I'm not going to get into what they miss in this conversation, but you also need to be verifying. A lot of times, they end up missing legal descriptions if you want to really know. But that's a whole nother topic and discussion, so we won't get into that. But title commitments, don't wait. Pull that title. Try to find that title. Get in there. Find out what's going on there. And within Schedule B, you're looking for covenants. You're looking for restrictions. You're looking for easements, maybe a maintenance agreement, master deeds, condo docs, private road agreements, and association rights. As you can see, there's a ton of things in that Schedule B, and it will list declarations of restrictions recorded at LIBOR blank, page blank. So it will start spelling it out what those restrictions are. And the buyer agent should obtain the documents and have those reviewed before your due diligence is up. Now you're saying, well, what documents? Well, yeah, you're going to find out by knowing if there's a restriction on the property that there's an association. So we need to reach out to that association. We need to get all the documents, master bylaws, you name it. Any type of restriction that's on there, we need that information for your client to make a determination on whether this property meets their intended use. Now, I don't know, so many times I've called listing agents and they verbally have told me, no, there's no HOA. Or, yeah, hey, I don't know if you've ever heard this one. Yeah, there's an HOA, but it's not active. Huh? An HOA, whether it's inactive or active, is still an HOA. And just because it's inactive doesn't mean that it can't become more active. Okay. Uh, so you need to never rely on what the listing agent tells you. They're there to try to help us, but unless they truly have done all of their due diligence and homework, we don't know whether it's really true, all the truth or not. And sometimes a listing agent might not know because of their experience, which is fine. But it's your job as a buyer's agent to verify all the information. So I often ask, is there an HOA? Is there a condo association? Is it a private road agreement somewhere? If there isn't, seller probably should hire an attorney and create one. What about a lake association? Yes, make sure you're verifying you're reading it. Deed restrictions. Agents should understand what dues are for a homeowner association or condo. Are there any pending assessments? A lot of times when you transfer from a condo, you might have to pay an assessment fee up front. And then what are the rules on pools, fences, sheds, pets, parking? And who manages the association is going to be a big one for your client. If there is an association, they're going to want to know who to call and who to reach out to verify the information within the homeowners or a condo association. And I think the biggest thing that we typically forget is, are there any pending lawsuits? Is the HOA or condo currently under pending litigation? That's a big one because your buyer may dig a little deeper into a pending lawsuit or talk to the county register and find out, well, yeah, they're being sued for $10 million. Well, what happens when there's a judgment against the condo association or HOA? That's going to get passed on to the owners. That's a real problem. So all of a sudden, you could have a huge special assessment that gets put on your buyer who's getting into this new condo. They're all excited and then realizes, hey, guess what? You have another $10,000 assessment each year for the next 10 years. Oh, great. Not a fun position to be in. So, another place that people can go to verify is Lara or Michigan Business Registry, because a lot of the associations, they are businesses, right? Especially if the association is incorporated. Now, we normally don't think about associations being a business or incorporated, but they can be. So we need to search. We can search the association name through Lara or the Michigan Business Registry, and this may help you determine whether the association entity exists, whether it appears active, and who may be listed as the resident agent or contact for that. So there's a lot of different ways that we can go about trying to find associations and who's overseeing them. There might be an association website or management company that we can go to. And if you can get in touch with the website or management company, this is where you're going to get all the documents, bylaws, the HOA declarations and restrictions. They're really called Declaration of Covenants, Conditions, and Restrictions, CC&Rs, these big fancy words that they use. But these are primarily the legal binding documents that establish and govern homeowners associations. You'll have rules and regulations. You might have, like we talked before, architectural guidelines, dues and assessment schedules, transfer fees. Resale requirements is always a big one. I'm just letting you know that there is a ton of information anytime we go down the path of an HOA or a condo association, and understand that active associations versus recorded restrictions. And there's a difference here. Agents should understand the difference between an active HOA and recorded restrictions because they are different. An active association may have a board, it may have dues, it may have management company, it may have rules, meetings and notices, and enforcement rights. Whereas recorded restrictions, when we see just recorded restrictions, they may still affect the property even if the association appears inactive. So active associations means there's much more authority. You can actually speak with someone and talk with them compared to just a recorded restriction on the property. Even though there's no association, it can still be enforced at some time later. Uh, so understand as buyer's agents, we should always be reviewing master deeds, condo bylaws, HOAs, and declarations, any type of recorded amendments, anything that may affect the property. And here's a big thing that I think when we're sitting down and we're meeting with the buyers, ask questions. Do you plan to install a pool? Do you need a fence? Do you plan to rent the property? Do you need to park a boat, an RV, a trailer, truck, or commercial vehicle? Uh, do you want pets, chicken, livestock? There's a lot of townships that allow so many chickens. Uh, you just need to ask if they plan what their plans are and understand that if it doesn't meet their intended use, you need to get out long before the due diligence inspection period is over. And some best practices, ask the buyer intended questions early in the process. Always review the MLS, seller's disclosure, title work, and recorded documents. Ask the listing agent direct written questions. So many times I think we're afraid to reach out to the listing agent and ask them very specific questions about the HOA or the condo or subdivision, whether it's a private road or lake association. The great thing is that as professionals, hopefully they've done their job as a listing agent and we can actually have a nice conversation because ultimate goal between us is to ensure that both parties have come together and it's been a pleasant experience. There's nothing worse than having a transaction. You go through it and both parties are miserable and they're fighting and the agents are mad at each other. It's a terrible position to be in. And then if you do have your buyer who's telling you specifically they want an in-ground pool or they want a pool barn, confirm your buyer's decision, everything in writing, not so much text. I would recommend getting away from text. Text sometimes I think, at least when we go down lawsuits, Don and I, and we're looking at things and we see this jumbled amount of texting between agents. And some of the things that you agents say, I question because I'm like, well, I wouldn't say that. But I'm just saying, keep it professional. Use emails, put something, make it so that we can follow in case there's ever an issue, and always document what your client is telling you to do or what they're asking of you. If it's a pool, a pole barn, get it and confirm it in writing somewhere. Or if they're saying, hey, I know I told you I wanted a pool, but I guess this is a home we really want. We're okay not having the pool. Fine. Hey, we had a great conversation. Thank you for letting me know that you still want to move forward, even though this home doesn't fit your intended use of getting a pool. That will save you, that will cover you a lot from one, failing in your fiduciary responsibilities from a legal standpoint, and number two, that you now have documentation from your client that you verified something and they've given you permission to still move forward. Hopefully that makes sense. And then with listing agents, some best practices when you're listing a home is always ask the seller whether the property is subject to an HOA or a condo association or a private road or lake association or deed restrictions or architectural control. And then you're going to want to request governing documents from the seller. You're going to upload available documents to the transaction file. You definitely want to confirm dues, assessments, transfer fees, and management contact information. with the local association or condo association. And then I encourage you to avoid saying no HOA unless verified. I don't know if you've ever seen that on the MLS. The listing agent will try to say, well, no HOA, buyer to verify. Come on. I mean, I think as listing agents, I think we can try to dig down a little bit deeper or spend an extra day or two finding this information before going live or forcing your seller to provide us with proper information so that later down the road, no one's scrambling for all the information that we might need when an addendum comes over saying, hey, I need all these condo docs. Uh, Agents who are listing agents, I recommend that you never use the phrase the HOA, well, they never enforce that. Or don't worry, yes, you could build a fence. They don't, this is a non-active HOA. They don't enforce anything. I would leave that out. I wouldn't put yourself in the crossfire of saying something that's misleading or misrepresenting the property. And then if you do know of any known restrictions, it's your obligation to accurately provide that information. And then if you're if as a listing agent, if you're a seller, or if you're a buying agent as a buyer, if we need to refer them to legal counsel, please do so to get an interpretation of certain questions answered. And then also, there's anytime as a buyer's agent, there is language that we have. There's addendum language that you should always be using anytime there's an HOA or condo. Uh, a simple phrase that we have here, but there's so many of them out there, is that buyer's obligation to proceed with the purchase is contingent upon buyer's review and approval of all homeowner association, condominium association, subdivision, private road, lake association, deed restriction, architectural control, and other governing documents affecting the property, including all rules, bylaws, declarations, amendments, dues, assessments, transfer fees, and use restrictions. Seller shall provide documentation to the seller within blank days after the effective date. And then the big key is that the buyer may terminate this agreement by written notice on or before a blank date if the buyer determines in buyer's sole discretion that the documents, restrictions, etc., are unacceptable. So what we're setting this up is we're really saying, hey, look, give us all the documents. We need time to review this, maybe 5 days to review. And if my buyer doesn't like anything in here, we're terminating. We're not gonna play the game of someone trying to prevent us from getting the information going into an HOA or condo, because some of these things are so overbearing that it's a turnoff to your client and they just don't want to live in an HOA or a condo association or have such egregious architectural control over what they can do on the outside of their home. Or maybe they just want a simple fence and it has to be a certain height or a certain color. You just don't know. So it's always important when you're drafting language that you use a condominium or addendum that spells out granting your buyer the ability to review the documents and terminate if they need to. And then if you're unsure, you can always reach out to broker support. Again, we are not HOA attorneys in this profession. We shouldn't pretend to be. And agents, your job is really to identify red flags or request documents or track deadlines, confirm buyer instructions in writing, recommend legal counsel. Again, recommend legal counsel when interpretation or enforceability matters. I don't know how many times I can say this, but Five Star does not have a legal team. We are not attorneys. Don and I can help guide people, but ultimately, we should always be letting our clients know that if you need an attorney, you should get an attorney. You should retain an attorney if you have questions, and especially with HOAs and condos, because they can be very egregious uh, and very hard to change, just to let you know. So before writing an offer, if you're a buyer's agent should complete basic screening. Ask a buyer what their intended use is, review MLS listing to see whether any red flags are coming up, like dues that are showing a subdivision name or an association name, maybe a private road reference, and then review available seller documents. Hopefully, the listing agent gathered this information from the seller. Check on the seller's disclosure, check the MLS, check the HOA, check the association rules, the bylaws, check your title for declaration. Make sure there's no private road agreements. If there are, get that. Make sure it looks good. If you're on a lake, there's lake association documents. Um, and then ask the listing agent very direct questions. You can ask, is the property subject to an HOA? Is there a private road agreement? What are the dues? Are there any pending or approved special assessments coming up on this property? The one question are pools, fences, sheds, rentals, or pets, or RVs, or exterior changes of the building restricted? Who's the association contact? Are there any known violations? So as you can see, there are so many things that we should be asking. Yes, is this boring content? You bet it is. But boy, is it important content? You bet it is. Definitely is for your clients. And then decide whether the offer needs special language. If the buyer's intended use depends on the HOA or restriction approval, offers should include specific document review or intended use contingencies. Example, you know darn well your client wants a pole barn. You better put in a contingency in there that says that this offer is contingent upon buyer being able to get proper permits for a pole barn or notification from city or HOA for a pole barn approval on or before blank date. Otherwise, buyer has the right to terminate purchase agreement. There's so many ways that we can write that. That was probably not the best way, but you get the idea that we're trying to have time to review documents and be able to terminate before, if need be, during a certain time frame, if the home doesn't fit the client's intended use. So when you do write an offer, again, a lot of associations have condo addendums that help you, that can help your client get out of the purchase agreement if need be, based on whether the property meets the buyer's intended use. Hopefully, the listing side has done their job and provided you with all the information so that there aren't concerns or issues at the last minute of the deal. Um, but always include a document review contingency when appropriate. Include deadlines, require the seller to provide documents, and then address any intended use if it matters, and then confirm the buyer understands the deadlines and the intended use of the property. Uh, and again, you have a very short period for due diligence. If need be, you might extend the due diligence period for reviewing of all your association or condo association documentations. Uh, and there's a lot out there. Again, review title, search recorded documents if needed, verify association contacts, and then compare the documents to your buyer's intended use, and recommend legal counsel when appropriate. Uh, so the last thing I'd like to say is that after closing, everyone's happy. After closing is not the time to discover that the property doesn't fit the buyer's intended use. Hope everyone understands that. And if an issue is discovered after closing, the buyer should be advised to consult legal counsel. Don't try to get in there. They really need to talk to an attorney at that point. And the agent should not give legal advice about enforceability, waiver, or selective enforcement within association or damages or legal remedies. We're not attorneys. And again, HOA and condo review should start before the offer if you can. If you have a chance and you know that someone's interested in something, get this information done. Try to pull this information before the offer is submitted in order to protect your client as best you can. And also, it will make the due diligence period a little bit smoother for everyone to follow. Uh, and don't, again, don't try to find these things after you've closed because by then it's too late. So I know there's a lot there. I appreciate your time. I know HOAs and condos aren't the greatest. It's not the most enlightening topic, but this discussion was really just to make you aware that there's a lot of information out there, especially when you're dealing with condos and HOAs, and that there's multiple places to find information, and make sure you get it into the hands of your clients so that they can make a decision on whether this home meets their intended use. I hope
Perfect.
that
Thank
helps.
you,
And again,
Eric.
we're
Thank
always here.
you.
You can give us a call if you have
Yeah.
questions.
Thank you, Eric. So we're at 10 o'clock and I see some agents are dropping off. So thank you for coming today. I hope everybody has a great week. If you have any, we don't have time for a Q&A, but if you have any questions, please reach out to Eric. I'm sure he's happy to answer those, but we don't want to keep you here past the 10 o'clock. So I hope everybody has a great week and a great day. It was great to see you all. And reach out to broker support this week if you need us for anything. So have a great day.
Thank you.
Bye. Bye-bye.